Before we begin, a quick and important disclaimer. The content provided in this masterclass is for educational, historical, and entertainment purposes only. We will be engaged in a rigorous examination of actual legal precedents, archival court documents, and historical trends related to family law, marriage contracts, and divorce proceedings in early America. This analysis does not constitute professional legal advice. The historical case studies we will deconstruct reflect the specific legal frameworks, societal norms, and judicial interpretations of their respective eras. Analyzing these centuries-old legal strategies does not guarantee or predict potential outcomes in modern legal jurisdictions or contemporary family courts. Viewers are strongly advised to conduct their own due diligence and seek professional, licensed legal counsel for any personal domestic relations, family law, or civil litigation matters. Imagine the year is 1643. A woman named Anne Clark stands before the quarter court in Boston, Massachusetts. The air inside the meeting house is thick with the rigid, moralistic expectations we typically associate with the Puritan founders of New England. According to the traditional narrative taught in standard history curricula, this is a society of unquestioning obedience and strict religious conformity, where the concept of marital dissolution is virtually unthinkable, universally condemned as a severe sin against both divine law and the newly established colonial state. Yet, Anne Clark is not standing in this court to beg for forgiveness for a moral failing. She is standing there to firmly and legally demand a divorce from her absent husband, Dennis Clark, who had abandoned her for another woman. And shockingly, the Puritan magistrates grant it. They grant her an absolute divorce, granting her the right to remarry, a legal mechanism that was practically non-existent for ordinary citizens back in the mother country of England. This is not a historical anomaly or an isolated footnote in a dusty textbook. It is the opening salvo of a profound, hidden war over bodily autonomy, civil contracts, and personal liberty that has been buried in the archives of New England for centuries. When we hear phrases akin to a divorce now movement, our minds immediately jump to the no-fault divorce legislative revolutions of the late 1960s and 1970s, the modern feminist movement, or contemporary high-profile legal battles over vast marital assets. But the actual fight for the immediate, legally recognized dissolution of marriage, a movement characterized by radical defiance, brilliant legislative maneuvering, and fierce courtroom advocacy, started hundreds of years earlier, right in the heart of colonial and early Republic New England. We have been fundamentally misled about the origins of traditional American marriage and family values. By meticulously combing through centuries-old trial transcripts, forgotten personal diaries, sworn depositions, and the heavily guarded archival records of the New England historical societies, a completely different, highly complex reality emerges. We see a reality where everyday people leveraged incredible legal loopholes, orchestrated elaborate public testimonies, and weaponized the very religious doctrines meant to oppress them, all to systematically escape unwanted, abusive, or broken marriages. Within these fragile yellowed pages, written in fading iron gall ink, lies a specific coordinated strategy used by early Americans to force the colonial and early state courts into granting what was essentially the first iteration of accessible marital dissolution. Over the course of this deep dive, we are going to reveal exactly how they accomplished this monumental feat. We will examine the specific legal language they invented, the radical theological shifts they utilized to redefine marriage from an unbreakable sacred sacrament to a breakable civil contract, and how one particular set of precedents established in these small Massachusetts and Connecticut towns created a massive ripple effect that ultimately reshaped the entire trajectory of United States family law. There is a specific threshold of legal argumentation, locked away in these archives, that shifts the paradigm of everything we thought we knew about the legal subjugation of early American citizens, particularly women. This history matters to you today, right now, because the very legal fabric of the modern American family is woven directly from the threads of these exact archival rebellions. If you have ever looked at the modern justice system and wondered why family court operates the way it does, why the legal definitions of domestic partnership, alimony, fault, and asset division are so incredibly complex and often contradictory, the answers are not found merely in reading modern legislative statutes. They are buried deep in the precedent-setting battles of New England's history. Throughout this comprehensive masterclass, we are going to dissect the potential outcomes of these historical legal strategies and map them directly onto the historical trends that define our current, modern judicial system. This is not just a passive history lesson. It is a meticulous step-by-step deconstruction of how a seemingly powerless demographic managed to legally engineer their own freedom against seemingly insurmountable institutional odds. For the American audience watching this today, Understanding these historical case studies is absolutely crucial for comprehending the underlying mechanics of social and legal change in our country. We are going to break down how these early petitions were drafted with surgical precision. We will examine the exact socioeconomic conditions that prompted the demand for divorce to explode in regions like Massachusetts, Connecticut, and Rhode Island, while the southern colonies remained strictly bound to rigid English common law, a system which only allowed for a separation from bed and board but strictly forbade actual divorce and remarriage. We will explore the critical revolutionary shift in legal philosophy that allowed New Englanders to view marriage as a civil utility rather than a religious absolute. This single philosophical pivot became the ultimate legal weapon for generations of attorneys and citizens to follow. You will see firsthand how the arguments over property rights, the custody of children, and the precise legal definition of cruel and abusive treatment were fiercely debated, refined, and codified in these early courts. We will analyze the specific verbiage used in the archival petitions, words carefully chosen to trigger legal loopholes without inciting charges of civil disobedience. By examining these granular documented details, you will gain a profound, expert-level understanding of the evolutionary biology of American jurisprudence. You will see how the specific legal frameworks developed in the 1600s and 1700s laid the invisible but vital groundwork for the massive legislative overhauls of the 20th century. We will pull back the curtain on the archival evidence to show you the raw, unfiltered reality of how marriage and divorce have actually functioned in America, stripping away the nostalgic myths and presenting the hard, documented, irrefutable facts. This masterclass will equip you with a deep, highly nuanced perspective on the historical precedents that continue to influence state Supreme Court decisions, ongoing state-level family law reforms, and the highly charged cultural debates surrounding marriage in the United States today. The truth, painstakingly preserved in these New England archives, is far more dramatic, legally subversive, and systematically brilliant than the standard historical narrative would ever lead you to believe. To understand the sheer magnitude of this hidden legal rebellion, we must first completely dismantle the modern assumption that colonial courts were exclusively controlled by inflexible religious dogma. Imagine if you are an average citizen, perhaps a man named Michael residing in Boston in the current year of 2026. If Michael enters into a business partnership and the other party completely fails to deliver on the agreed-upon terms, Michael hires an attorney, files a breach of contract lawsuit, and the civil court dissolves the partnership. He is then completely free to engage in new business ventures. Surprisingly, this highly pragmatic, contract-based framework is exactly how the early Puritan magistrates viewed the institution of marriage. Unlike the rigid ecclesiastical courts back in England, which operated under the strict Catholic and Anglican doctrine that marriage was a permanent, unbreakable religious sacrament, the founders of New England instituted a massive theological and legal pivot. They stripped marriage of its sacramental status entirely. They officially reclassified it as a civil contract. This was not merely a philosophical difference. It was a highly strategic, foundational legal shift that created an immediate, exploitable loophole for trapped spouses. Because if marriage was legally defined as a civil contract, it inherently possessed specific, enforceable terms of agreement. And logically, if those terms were egregiously violated, the contract could be legally rendered null and void by a civil authority. This brings us to one of the most fascinating historical trends in the development of American family law, which is the weaponization of the desertion statute. Throughout the mid to late 1600s, the New England economy was heavily reliant on maritime trade, frontier exploration, and transatlantic commerce. Husbands frequently left their settlements for months or even years at a time. In many documented case studies, these men simply never returned. Some perished at sea, some relocated to other colonies to escape debts, and others established entirely new, bigamous lives back in England or in the Caribbean. For the women left behind, the potential outcomes under traditional English common law were absolutely catastrophic. Under the strict legal doctrine of coverture, a married woman possessed virtually no independent legal identity. Her entire legal existence was suspended and absorbed into that of her husband. This meant an abandoned wife was completely paralyzed within the legal system. She could not legally sell any property to feed her children, she could not legally execute contracts to run a business, she could not sue debtors to collect money owed to her husband, and she certainly could not remarry to secure a new source of financial stability. She was trapped in a perpetual state of legal and economic limbo. Faced with the imminent threat of starvation and absolute destitution, these early American women did not passively accept their fate. Instead, they began executing a highly coordinated legal strategy, flooding the general courts with petitions for total marital dissolution. They did not argue for divorce based on modern concepts of emotional incompatibility or a desire for personal fulfillment, because they knew the magistrates would immediately dismiss such claims. Instead, they brilliantly framed their petitions around the immediate threat to the economic stability of the community. A destitute, abandoned wife and her starving children would inevitably become a massive financial burden on the local town treasury. The colonial magistrates despised nothing more than allocating public funds to support the poor. By legally granting an absolute divorce, the magistrates simultaneously dissolved the broken civil contract and legally freed the woman to remarry. This effectively transferred the financial responsibility of providing for the woman and her children from the town budget to a brand new husband. It was a cold, calculated, economic transaction disguised as moral justice. Let us look at the specific step-by-step mechanics of this strategy through the documented case study of a woman named Dorothy Pester. In the year 1652, Dorothy stood before the magistrates of the Essex County Court in Massachusetts. Her husband, William, had vanished to England several years prior, leaving her without any financial provisions, land titles, or means of basic survival. Dorothy did not simply walk into the meeting house and demand a separation. She executed a precise, multi-tiered legal process that mirrors modern due diligence. First, she secured sworn, notarized testimonies from ship captains and traveling merchants to establish a legally binding timeline of William's exact departure and his continued absence. Second, she gathered depositions from upstanding male members of the community to testify to her own impoverished state and her moral fortitude during her husband's absence, legally precluding any counter-accusations of her own misconduct. Finally, she submitted a formal, heavily researched petition arguing that William had not just left her, but had willfully destroyed the foundational terms of their civil contract. The magistrates reviewed the overwhelming evidentiary record, recognized the immense economic liability she posed to the town, and issued a landmark ruling. They did not merely grant her a temporary separation, they officially granted her the liberty to marry another man. This exact phrase, preserved in the court records, completely severed the marital bond. It was a total legal victory that established a rock-solid precedent for hundreds of other abandoned spouses across the region. But while leveraging abandonment to secure a divorce was a straightforward, almost mathematically predictable legal maneuver, it was incredibly narrow in its application. It required the offending spouse to be physically absent from the continent for an extended period of time. The real, significantly more dangerous battleground for legal autonomy occurred when the offending spouse was still living under the exact same roof. The historical trends reveal that as the colonies expanded and the population grew, everyday citizens began demanding that the courts recognize an entirely different, vastly more complicated breach of the civil contract: extreme cruelty and severe physical abuse. This required an entirely different, highly volatile legal strategy. How does a spouse legally prove intolerable cruelty in an era where the legal statutes actually permitted a husband to physically discipline his wife and servants to maintain household order? It required shifting the legal argument from a simple matter of a broken financial contract to a highly complex, highly publicized examination of the exact threshold of physical violence. It required bringing the darkest, most closely guarded secrets of the private domestic sphere directly into the glaring public spotlight of the colonial courtroom. They had to systematically prove that the violence had escalated from acceptable, legally sanctioned discipline into completely unauthorized, life-threatening tyranny. And to win these specific, high-stakes cases, petitioners had to orchestrate a public spectacle of neighborly surveillance that could easily backfire and destroy their own reputations. How exactly did they walk this razor-thin legal tightrope, especially when the person they were accusing of abuse was a wealthy, influential member of their own community? The exact courtroom tactics they deployed, and the shocking witness testimonies they managed to extract, will fundamentally alter your understanding of colonial justice, and those explosive details are precisely what we are going to uncover next. To understand exactly how these early Americans successfully proved extreme cruelty, we must first completely immerse ourselves in the brutal, highly patriarchal legal reality of the colonial era. In the vast majority of 17th and 18th century jurisdictions, a husband was legally permitted, and in many religious contexts actively encouraged, to use physical force to discipline his wife and maintain strict household order. This was not considered abuse. It was classified under the law as moderate correction. The colonial legal framework operated on a strict hierarchy where the husband acted as the absolute sovereign over his domestic sphere. Therefore, filing a petition for divorce on the grounds of physical abuse was an incredibly dangerous gamble. If the magistrates determined that the violence was justified by the wife's insubordination, or if they deemed the physical force to be within the acceptable limits of moderate correction, the petition would be violently rejected. The wife would then be legally forced to return to the home of the very man she just publicly accused, facing catastrophic social and physical retaliation. Imagine if we fast forward to the current year 2026. A woman named Jessica is involved in a domestic dispute and seeks a legal separation. Today, her legal representation can utilize a vast array of evidence, including digital communications, psychological evaluations of coercive control, financial withholding, and any degree of unwanted physical altercation. The modern court system recognizes a wide spectrum of abuse. Now transport that exact same scenario back to a Massachusetts courtroom in the year 1675. Emotional cruelty was legally invisible. Financial withholding was simply the husband's legal prerogative under the doctrine of coverture. To secure a divorce based on cruelty, the physical violence had to be so exceptionally severe, so fundamentally horrific, that it transcended the husband's legal right to discipline and crossed over into attempted murder or life-threatening tyranny. This brings us to the meticulous, highly strategic gathering of witness testimonies found buried in the archival records. Women could not simply testify on their own behalf. Their words held virtually no legal weight against a husband's denial. They needed a coordinated, heavily documented public spectacle. The historical trends reveal a fascinating sociological phenomenon unique to early New England settlements. These towns operated as massive, interconnected surveillance networks. Houses were constructed in close proximity, walls were incredibly thin, and the moral policing of neighbors was considered a civic and religious duty. Women seeking to build a legal case for divorce systematically weaponized this surveillance state. We see this exact strategy deployed in a myriad of historical case studies from the Connecticut Superior Court records. When a husband began his physical assault, the wife would not simply endure it in silence. Archival depositions show that women would intentionally scream at the highest possible decibels, forcefully throwing open their windows, or deliberately fleeing out into the snow or the muddy streets. This was not merely panic. This was a calculated legal maneuver to break the private boundary of the home and enforce the violence into the public square. By ensuring that the assault was witnessed by multiple property-owning male neighbors, the wife was actively generating the exact type of sworn, notarized affidavits she would need for her future petition. The neighbors would later testify under oath not just that a beating occurred, but that the violence was so chaotic, so unnatural, that it violently disturbed the peace of the entire settlement. Once inside the courtroom, the legal battle shifted to dismantling the husband's ultimate defense, which was the defense of provocation. The historical records are filled with husbands arguing that their wives were disobedient scolds, that they neglected their domestic duties, or that they challenged patriarchal authority, thereby making the physical beatings a legally justified, necessary correction. To defeat this, early American attorneys and petitioners engineered a brilliant theological and legal counterargument. They did not just argue about the severity of the bruises, they argued about the fundamental nature of the civil contract. They asserted that while a husband had the right to govern, he was legally and spiritually obligated to govern with the protective care that a sovereign owes to their subjects. When a husband crossed the line into extreme life-threatening violence, he was no longer acting as a legally sanctioned head of household. He was acting as a completely lawless, chaotic tyrant. By framing the abusive husband not just as a bad spouse, but as a dangerous, destabilizing threat to the entire colonial social order, the petitioners successfully manipulated the magistrates' deepest fears. The colonial courts were utterly terrified of anarchy and social breakdown. If they allowed a husband to murder or permanently maim his wife without consequence, they would be endorsing lawlessness. We see case after case where the magistrates, presented with a mountain of undeniable physical evidence, bloody garments presented in court, and the sworn testimonies of the town's most respected elders, were forced to act. They dissolved the marriage not out of modern empathy for the battered woman, but to legally amputate a diseased, chaotic element from their strictly ordered society. They granted the divorce to restore public order, inadvertently handing women the ultimate legal victory and their bodily freedom. Through these brutal, highly publicized legal battles, The threshold for legally recognizable extreme cruelty was slowly but permanently established in American jurisprudence. Everyday citizens forced the highest courts to strictly define exactly how much violence a human being was legally expected to endure before a civil contract was deemed irreparably broken. They systematically built a wall of legal precedents, case by bloody case, that eventually became the foundation for domestic violence statutes hundreds of years later. But escaping the physical danger of a tyrannical husband was only one half of the legal war. When these magistrates banged their gavels and declared the marriage contract officially dissolved, they immediately triggered an entirely new, infinitely more complex legal crisis. A woman might walk out of that meeting house with her life and her bodily autonomy secured, but under the harsh reality of colonial law, she was walking out with absolutely nothing else. Every single piece of property she brought into the marriage, every coin of her dowry, every piece of inherited land, and the very clothing on her back legally belonged to the man she just divorced. The physical chains were broken, but the economic chains remained firmly locked in place. How could a newly divorced woman possibly survive in a harsh, unforgiving frontier economy with zero assets, zero legal credit, and a society that still viewed her with intense suspicion? To answer that, we have to look at the next wave of archival petitions, where these early Americans launched a massive, unprecedented legal assault to forcefully reclaim their wealth, their stolen property, and the children they were forced to leave behind, and the complex financial mechanics of how they pulled off this impossible secondary victory will completely change how you view modern alimony. The absolute erasure of female financial identity under the English common law doctrine of coverture is one of the most widely misunderstood concepts in American legal history. To truly grasp the catastrophic economic reality facing a newly divorced woman in the late 17th century, we have to look at the precise mechanics of this doctrine. Under coverture, the very second a woman uttered her marriage vows, her independent legal existence was entirely extinguished. She became a femme covert, a covered woman. Every single coin she possessed, every acre of land she inherited, every piece of silver she brought into the home, and even the physical wages she might earn from spinning wool or selling eggs instantly became the absolute, uncontested legal property of her husband. He could sell her ancestral farmland to pay off his own gambling debts without her permission. He could legally seize the inheritance left to her by her own parents. Therefore, when a colonial magistrate granted a woman a divorce on the grounds of extreme cruelty or abandonment, he was essentially severing her from her only legally recognized source of financial sustenance. Imagine if we look at a woman named Emily living in Chicago in the current year 2026. If Emily files for a divorce today, she operates under a legal architecture of equitable distribution or community property, depending on her state. Her attorneys will subpoena bank records, evaluate retirement accounts, and fight for a fair division of the marital assets that were accumulated during the marriage. Furthermore, Emily retains complete ownership of any premarital assets she brought into the partnership. Now superimpose that modern expectation onto the freezing, unforgiving reality of a New England settlement in the year 1680. When a woman walked out of the meeting house with her legal decree of divorce, she walked out with literally nothing. The husband retained the house, the livestock, the farming equipment, the bank accounts, and all of her premarital possessions. Legally, the very dress she was wearing belonged to the man she had just divorced. Faced with this systemic financial annihilation, early American women and their legal advocates engineered a secondary, highly sophisticated legal rebellion. If they had successfully convinced the courts that marriage was a civil contract rather than a religious sacrament, they logically deduced that the dissolution of that contract must be governed by standard commercial law. They began filing aggressive secondary petitions demanding the immediate return of their original capital investments, which in the context of colonial marriage, was the dowry or the bridal portion. They argued that if a merchant entered into a shipping contract and the opposing party maliciously destroyed the cargo, the injured merchant was legally entitled to full restitution. By directly mapping commercial contract law onto domestic relations, these women argued that an abusive or absent husband had maliciously destroyed the marriage contract, and therefore, he had entirely forfeited his legal right to her initial financial contribution. The historical trends preserved in the archival ledgers of the Massachusetts Bay Colony reveal exactly how successful this brilliant legal strategy was. We see meticulously detailed case studies where women, immediately upon securing a divorce, submitted exhaustive, line-by-case inventory lists to the magistrates. They did not ask for a share of his wealth. They demanded the precise extraction of their own. They listed specific acreage of meadowland, exact numbers of sheep and cattle, distinct pieces of heirloom pewter, and precise weights of silver coin that their fathers had given them upon their wedding day. The magistrates, bound by the very civil contract logic they had established to grant the divorce in the first place, were forced to agree. They began issuing historic legal decrees ordering the at-fault husbands to completely refund the dowries. This forced extraction of wealth from the patriarchal estate back into the hands of an independent woman was a completely radical redistribution of capital, and it laid the absolute foundation for what we now understand as the division of premarital assets. But recovering a dowry only helped women who came from wealthy families. What about the working-class women who brought no initial capital into the marriage? To save these women from complete starvation, the colonial legal system birthed the earliest American iterations of alimony. However, the potential outcomes of these early alimony rulings were not driven by any modern sense of feminist equity or moral obligation to the battered wife. They were driven entirely by the ruthless, pragmatic fiscal policy of the Puritan magistrates. A destitute, divorced woman with no assets would immediately become a ward of the state, requiring the local town to use taxpayer funds to provide her with food, firewood, and shelter. The magistrates absolutely abhorred raising local taxes to support the poor. Therefore, they invented a legal mechanism to force the abusive husband to bear the financial burden of his own contractual breach. They ordered him to pay a specific, ongoing stipend to his ex-wife, not to enrich her, but to actively protect the town treasury. Early American alimony was fundamentally a taxpayer protection scheme disguised as domestic justice. Securing physical safety and a meager financial stipend were monumental victories, but they paled in comparison to the most agonizing, high-stakes battleground of the early American divorce movement, which was a total warfare over child custody. Under the strict confines of English common law, children were essentially classified as the property of the father. He possessed the absolute right to their labor, their earnings, and their physical custody. When a marriage dissolved, the default legal assumption was that the father would retain the children, and the mother would be permanently banished from their lives. Overcoming this immense legal hurdle required an entirely different, incredibly dangerous courtroom strategy. A mother could not simply argue that she was the more nurturing parent, as maternal preference held absolutely zero legal weight in the 17th century. To strip a father of his legal property rights over his own children, early American women had to systematically prove that leaving the children in his care posed an existential threat to the survival of the colonial state. They utilized the exact same network of neighborhood surveillance that they used to prove physical cruelty. They gathered sworn depositions testifying that the father was not just abusive to his wife, but that he was a chronic drunkard, a public blasphemer, or a man who actively refused to provide religious and moral instruction to his household. They brilliantly argued that placing children in the custody of such a man would actively breed a new generation of criminals, debtors, and heretics who would eventually destroy the entire settlement. By framing the husband's character as a direct threat to the future stability of the Commonwealth, women forced the courts to override the father's common law property rights in order to protect the public good. They slowly, painfully carved out the very first legal precedents for what would eventually evolve into the modern legal standard of the best interests of the child. They achieved the impossible, securing physical freedom, recovering stolen wealth, and rescuing their children from patriarchal absolute rule. They had successfully weaponized the civil contract nature of marriage to dismantle their own oppression. But this unprecedented wave of female legal empowerment did not go unnoticed. As the courts granted more and more power to these petitioning women, a massive, terrifying backlash began to brew among the men of New England. Recognizing that the legal landscape had fundamentally shifted, husbands realized they too could weaponize the exact same civil contract laws, but they would use them not for liberation, but for absolute vengeance. What happens when the very legal framework designed to protect victims is suddenly hijacked by the abusers, utilizing completely fabricated accusations of the most severe, legally fatal crimes known to the colonial world? And how did this counterattack nearly destroy the entire divorce movement overnight? The immediate and terrifying consequence of women successfully weaponizing the civil contract of marriage was a massive, highly coordinated legal counterattack engineered by the men of New England. Once husbands realized that the colonial courts were actually willing to dissolve marriages and redistribute assets based on breach of contract, they recognized a profoundly dark opportunity. If the legal framework existed to sever the marital bond, men could utilize that exact same framework to rid themselves of unwanted wives, secure younger brides, or completely absorb their wife's premarital wealth without the burden of paying ongoing alimony. However, a husband could not simply walk into the general court and claim abandonment if his wife was sitting right there in the parlor, nor could he easily claim physical cruelty against a woman in a society that already granted him the legal right to dominate her. To achieve total victory, husbands had to accuse their wives of the ultimate, unforgivable breach of the civil contract. They had to accuse them of the most legally fatal crimes known to the colonial world, with the primary weapon of choice being the devastating charge of female adultery. To comprehend the sheer legal violence of this tactic, we have to examine the extreme gender double standards embedded in 17th century jurisprudence. Under the historical trends of early American law, male infidelity was often legally classified as a mere misdemeanor, a minor property violation against another man if the woman was married, or simple fornication if she was unmarried. It rarely resulted in a granted divorce petition for the wife. Female adultery, however, was legally classified as a catastrophic crime against the state, the family unit, and the divine order. In the earliest days of the Massachusetts Bay Colony, female adultery was actually written into the statutes as a capital offense punishable by death. Even as the decades progressed and executions for infidelity became exceedingly rare, the statutory punishments remained completely ruinous. A woman found guilty of adultery faced public whipping, permanent physical branding, forced public humiliation on the town scaffold, and total unmitigated exile from her community. Imagine if we look at a man named David, living in a suburb of Chicago in the current year 2026. If David decides he no longer wants to be married to his wife, he simply files a no-fault divorce petition. He pays his legal fees, the modern court equitably divides their mutual assets, child support and alimony are mathematically calculated, and they both go their separate ways. Now, project David back into the heavily surveilled, religiously zealous environment of a New Haven settlement in the year 1692. David wants to dissolve his marriage, but he absolutely refuses to surrender the fertile farmland his wife brought into the marriage as her dowry, and he refuses to pay any alimony to the town treasury for her ongoing survival. To achieve this, colonial David cannot just file paperwork. He must orchestrate a highly coordinated criminal conspiracy to legally annihilate his wife's character and frame her for a catastrophic felony. If he successfully proves she committed adultery, the court will grant him an absolute divorce, but because she is the criminal party, she legally forfeits every single ounce of her property, her dowry, and her children. She is financially liquidated and banished, leaving David with 100% of the marital estate. This is exactly what began happening in the colonial courts, leading to a horrifying spike in male-initiated divorce petitions based on entirely fabricated accusations. Let us analyze a composite case study drawn from the archival ledgers of the Middlesex County and Essex County courts. A wealthy merchant, desiring to dissolve his marriage, would initiate a systematic campaign of witness tampering and perjury. Because the early legal system relied so heavily on community surveillance and neighborly testimony, the merchant would leverage his vast economic power over his indentured servants, his tenant farmers, and the local men who owed him massive debts. He would coerce these individuals into providing sworn, notarized depositions claiming they had witnessed his wife engaging in illicit behavior with a farmhand or a traveling sailor. The step-by-step execution of this strategy was meticulously planned. The husband would intentionally leave town on a business trip, ensuring his wife was left completely isolated on the property. His hired witnesses would then fabricate a timeline of events, using highly specific, legally triggering verbiage in their testimonies to guarantee the magistrates would be forced to open a formal criminal investigation. When the wife was dragged into the freezing meeting house to face these charges, she found herself completely trapped in a legal nightmare. She was not entering the court as a civil petitioner seeking relief. She was entering as a criminal defendant fighting for her actual life. Because she was a married woman under the doctrine of coverture, she possessed no independent wealth to hire her own legal counsel. She stood entirely alone against the overwhelming, highly coordinated testimonies of men who were legally sworn to tell the truth. The magistrates, inherently terrified of secret sins and moral decay within their utopian settlements, were heavily biased toward believing the sworn affidavits of property-owning men over the frantic denials of an accused woman. The potential outcomes were devastatingly predictable. The courts granted the husbands the divorces they sought, completely stripping the accused women of their wealth, their social standing, and their right to ever see their children again. This malicious counterattack was so devastatingly effective that it nearly destroyed the entire divorce now movement overnight. Husbands across New England were successfully gaming the system, transforming the civil contract loophole from a tool of female liberation into an instrument of absolute patriarchal terror. But in their greed, these husbands made a catastrophic systemic miscalculation. By utilizing fraudulent testimonies to legally discard their wives without financial restitution, they were suddenly flooding the colonial towns with completely destitute, socially ruined women. These exiled women had absolutely no means to feed or shelter themselves during the brutal New England winters. They immediately became wards of the state. The magistrates quickly realized that their courts were being heavily manipulated by deceitful husbands, and as a direct result, the local town treasuries were being completely drained to support this massive new population of impoverished, divorced women. The economic liability that the magistrates had tried so hard to avoid had returned with a vengeance. The colonial justice system was suddenly facing an existential crisis of its own making. The magistrates realized that they could no longer rely on the hearsay and manipulated testimonies of the local surveillance network. To stop this epidemic of fraudulent mail petitions and protect the financial stability of their towns, the courts had to radically alter the rules of engagement. They had to completely strip the power of narrative away from these manipulative husbands and ground the civil contract of marriage in undeniable, empirical, physical proof. To achieve this, the colonial legal system was forced to invent an entirely new, incredibly invasive form of forensic jurisprudence. They moved the battleground from the public testimonies of the meeting house directly onto the physical bodies of the accused citizens. They established specialized, highly secretive juries and mandated horrific physical examinations that blur the line between judicial process and medical terror. The exact details of these archival court-ordered bodily inspections, and the secret network of women who were legally empowered to perform them, will completely shatter your perception of early American privacy, and we are going to expose the mechanics of those deeply hidden records right now. The realization that oral testimony was inherently corruptible forced the New England magistrates to execute a terrifying legal pivot. If a husband wanted to legally discard his wife by accusing her of illicit affairs, or conversely, if a wife sought to dissolve the contract by claiming her husband was physically incapable of fulfilling his marital duties, the colonial courts decreed that verbal accusations and neighborly hearsay were no longer sufficient. They demanded empirical anatomical proof. To acquire this undeniable physical evidence, the legal system resurrected a deeply invasive, ancient English common law mechanism known as the jury of matrons. Because strict colonial modesty laws absolutely forbade male magistrates, constables, or male physicians from physically examining a female citizen, the courts were forced to legally deputize a specialized panel of local midwives, respectable older women, and experienced mothers. These women were suddenly granted unprecedented, terrifying judicial authority to forcibly examine the private bodies of the accused. Imagine if we look at a woman named Sarah, living in Seattle in the current year 2026. If Sarah is involved in a highly contentious family court battle where paternity or fidelity is aggressively questioned, establishing the medical truth might involve a completely sterile, highly regulated DNA cheek swab. This process is handled by neutral medical professionals under the strictest privacy laws, shielded by attorney-client privilege and health information protections. Now, absolutely strip away all modern concepts of bodily autonomy, medical privacy, and personal dignity, and transport Sarah back to a freezing Massachusetts courtroom in the year 1695. The magistrates, responding to her husband's petition for divorce based on a claim of a hidden pregnancy, legally order a physical inspection. Sarah is not sent to a private medical facility. She is escorted by the town constable into a locked, drafty back room adjacent to the public meeting house. Waiting for her inside are 6 to 12 women from her own village. These are not anonymous, dispassionate medical professionals. These are her direct neighbors, the women she trades grain with, the women whose children play with hers, and the women she sits next to during grueling Sunday sermons. These local women have been placed under a legally binding oath by the highest authority of the colony to strip Sarah naked, physically probe her body, and conduct a deeply invasive search for any anatomical evidence of recent childbirth, concealed pregnancies, illicit diseases, or any physical signs that contradict her sworn testimony. Let us examine the exact historical trends and step-by-step procedural mechanics found in these highly guarded archival case studies. The court would issue a formal, written warrant to the local constable, legally compelling the immediate formation of this jury of matrons. The archives contain the actual sworn returns of these juries, documents written in cramped, fading ink, utilizing highly technical 17th-century medical terminology. The matrons would conduct their severe physical examination, meticulously searching for the expansion of the abdomen, the production of milk, or the physical aftermath of a concealed miscarriage. Once their grueling inspection was complete, they did not offer a mere opinion. They drafted a legally binding collective verdict. They would march back into the public courtroom, stand before the elevated bench of the male magistrates, and deliver their sworn, unified findings onto the official public record. The historical records reveal a shocking truth about the potential outcomes of these highly secretive examinations. The sworn testimony of these deputized women was considered absolute, irrefutable medical fact. Their written return completely superseded the verbal testimony of wealthy merchants, angry husbands, and even the local clergy. If the jury of matrons returned a verdict stating that they had meticulously searched the accused woman and found absolutely no physical evidence whatsoever to support the husband's claims, the entire fabricated legal conspiracy engineered by the manipulative husband instantly collapsed. The male magistrates, strictly bound by the empirical findings of the matrons, would forcefully deny the husband's petition for divorce. But the legal consequences did not stop at a simple denial. Because the husband had initiated a fraudulent criminal proceeding that directly threatened the financial stability and moral order of the town, the court would frequently turn its judicial wrath entirely upon him. The magistrates would levy catastrophic fines for perjury, malicious prosecution, and defamation, effectively bankrupting the very men who had tried to manipulate the civil contract system for their own financial gain. What began as a desperate, pragmatic measure by the patriarchal courts to verify the truth inadvertently created a massive, temporary transfer of ultimate judicial power directly into the hands of colonial women. The historical trends heavily suggest that these juries of matrons did not operate strictly as cold, impartial instruments of the state. These deputized women possessed a profound, intimate understanding of the brutal reality of colonial marriage within their specific settlements. They knew exactly which husbands drank their wages away. They knew which men were excessively cruel behind closed doors. And they deeply understood the catastrophic financial ruin, starvation, and social exile awaiting a falsely accused wife. Archival evidence strongly implies that these juries frequently deployed their medical authority as a massive localized protective shield. They actively weaponized biological ambiguity. If the physical evidence was even slightly inconclusive, or if there was any room for medical doubt, the matrons would consistently rule in favor of the accused wife. By doing so, they effectively stonewalled the male magistrates, legally overriding the husband's accusations and permanently protecting the vulnerable woman from financial liquidation. They essentially formed a legally sanctioned, highly covert sisterhood that actively sabotaged the fraudulent divorce petitions of abusive or greedy men. These women used the very mechanisms of state surveillance to dismantle the state's ability to oppress their neighbors. The colonial magistrates, witnessing case after case collapse due to the unified testimonies of these midwives, quickly realized they had made a grave systemic error in their legal architecture. By demanding undeniable physical proof, they had inadvertently handed the ultimate legal trump card to interconnected networks of local women. The patriarchal justice system was being routinely legally outmaneuvered by the very female citizens it sought to govern and control. The courts realized that relying on the biological testimonies of deputized women to adjudicate the civil contract of marriage was far too dangerous and unpredictable for the preservation of the social hierarchy. They needed to immediately strip this absolute judicial power away from the juries of matrons and move the fierce battleground for marital dissolution into an entirely new, infinitely more public, and vastly more commercial arena. They shifted the focus away from the hidden physical bodies of the accused and directed it strictly toward the absolute destruction of public reputation and commercial credit. To achieve this monumental shift in legal strategy, the courts and the warring spouses turned away from the meetinghouse backrooms and looked toward the most devastating new communication technology of the early 18th century. How did the sudden explosion of the American printing press and the aggressive weaponization of the runaway wife newspaper advertisement completely redefine the legal mechanics of divorce? And why did this specific, highly public tactic permanently alter the foundational landscape of American commercial law? The fundamental shift from the closed-door, deeply invasive physical examinations of the meetinghouse to the highly public commercial warfare of the 18th century was triggered by the sudden, explosive rise of the American printing press. As localized newspapers began circulating throughout Massachusetts, Connecticut, and Rhode Island, the colonial legal system realized that public reputation and commercial credit were vastly more effective mechanisms for controlling the population than hidden anatomical inspections. To understand how the mechanics of divorce were entirely redefined by this technology, we must first completely dismantle our modern understanding of how people actually bought and sold goods. Hard currency, actual silver or gold coins, was incredibly scarce in the early American economy. Almost all daily commerce, from buying flour from the miller to purchasing cloth from the merchant, operated entirely on a complex, highly localized system of mutual credit and ledger books. Under the strict doctrine of coverture, a married woman acted essentially as a financial extension of her husband. She was his legal agent. When she purchased food for the household, the merchant simply recorded the debt under the husband's name, operating on the legally binding assumption that the husband was contractually obligated to pay for it. Imagine if we look at a man named Mark, living in Austin, Texas in the current year 2026. If Mark decides he wants to financially annihilate his spouse prior to a divorce, he might illegally attempt to freeze her modern credit cards, lock her out of their mutual banking applications, and systematically remove her name from the mortgage. Now, project that exact malicious intent into the colonial era, where a husband could achieve total financial destruction using nothing but a few ounces of black ink. Husbands who wished to rid themselves of their wives, or who wanted to preemptively block their wives from suing for alimony, began utilizing the printing press to execute a devastating preemptive legal strike. They paid local printers to publish what became legally known as runaway wife or elopement advertisements. These highly visible newspaper notices followed a very specific, legally weaponized formula. The husband would publicly declare to the entire colony that his wife had unlawfully eloped from his bed and board. In the context of early American law, elopement did not mean running away to secretly marry a lover. It was a precise legal term meaning she had abandoned the marital domicile without his explicit permission. The husband would then issue a stark, legally binding warning to all merchants, tavern keepers, and citizens, explicitly forbidding anyone from extending credit to his wife or harboring her under their roof. He formally declared that he would absolutely refuse to pay any debts she might contract. By publishing this single devastating paragraph in a widely read broadside, the husband completely severed his wife's legal agency. The potential outcomes for a woman targeted by one of these advertisements were absolutely catastrophic. The moment that newspaper hit the cobblestone streets, she was instantly, entirely locked out of the colonial economy. The historical trends preserved in these commercial ledgers show that local bakers, tailors, and innkeepers, terrified of not being compensated, immediately blacklisted the accused wife. She could not secure a loaf of bread, she could not buy firewood for the brutal winter, and she could not rent a room for shelter. She was rendered a financial ghost, publicly humiliated and starved into submission. The husband's objective was brutally simple. He wanted to legally force her back into the abusive home under his absolute control, or force her to flee the colony entirely, thereby legally granting him an uncontested divorce on the grounds of her abandonment, allowing him to keep all of the marital assets. But colonial women, possessing a staggering degree of resilience and legal ingenuity, did not just passively accept this commercial assassination. They realized that if the printing press could be weaponized to destroy them, it could also be weaponized to exonerate them. In a massive, unprecedented escalation of the Divorce Now movement, women began executing a brilliant counterattack. They scraped together secret funds, or utilized sympathetic male relatives, to purchase their own advertising space right next to their husbands' notices. These public rebuttals, highly documented in the archival case studies of early American newspapers, are some of the most extraordinary legal documents in history. The wives directly addressed the colonial public, explicitly refuting the charge of unlawful elopement. They utilized the exact same public forum to meticulously detail the extreme physical cruelty, the financial starvation, and the tyrannical abuse that had completely forced them to flee for their actual lives. They argued that they had not abandoned their marital duties, but rather the husband had completely destroyed the civil contract of marriage through his horrific violence, thereby making the home a complete hazard to their survival. This highly public battle of the broadsides created an absolute legal and commercial panic among the merchant class of New England. The local shopkeepers were suddenly thrust into the incredibly dangerous position of acting as impromptu family court judges. If a freezing, battered wife walked into a tavern asking for a room on credit, the tavern keeper faced an impossible legal dilemma. If he believed the husband's newspaper ad and refused her shelter, she might freeze to death in the street. But if he believed the wife's counter-advertisement and granted her a room, he ran the risk of the husband refusing to pay the bill. When the tavern keeper inevitably sued the husband for the unpaid debt in civil court, the merchant's own financial survival suddenly depended on proving whether or not the husband had actually abused the wife. This specific commercial chaos forced the highest courts of the colonies to permanently alter the foundational landscape of American contract law. By formalizing the doctrine of the agency of necessity, the magistrates legally decreed that while a husband could indeed publish notices revoking his wife's standard credit, he absolutely could not sever his financial liability if his own extreme cruelty had forced her out of the home. The courts ruled that a battered wife carried an invisible, unbreakable line of credit for absolute necessaries, meaning food, clothing, and shelter. If a merchant provided those specific life-saving items to an abused wife, the courts would ruthlessly force the abusive husband to pay the bill, completely disregarding his newspaper advertisements. This ruling was a monumental victory for the physical survival of abused women, but it simultaneously unlocked a completely terrifying new legal strategy. Once women realized that the colonial courts would legally force their abusive husbands to pay for their survival items, regardless of any public denouncements, they realized they held the ultimate financial weapon. They no longer had to simply beg for a meager alimony stipend from the local magistrates. They could actively, aggressively manipulate the commercial credit system to completely bankrupt the men who had tortured them. How exactly did these desperate wives organize massive, coordinated spending sprees with sympathetic merchants to systematically drain their husbands' estates? And how did this explosive weaponization of retail debt finally break the patriarchal chokehold on the colonial divorce courts? The legal doctrine of the agency of necessity was originally intended by the colonial magistrates to be a highly restricted, conservative measure designed solely to keep battered wives from freezing to death in the public square and draining the local town treasury. However, the everyday women of early New England immediately recognized the massive unexploited loophole buried within this judicial ruling. They realized that the very same legal principle of coverture, the oppressive system that legally erased their financial identity and made them entirely dependent on their husbands, could actually be inverted and used as a weapon of total economic destruction. Because a married woman was still legally considered the financial agent of her husband, any debt she incurred for her own survival was his absolute, inescapable liability. What began as a desperate plea for basic sustenance rapidly evolved into a highly coordinated, devastatingly effective campaign of retail warfare. Imagine if we look at a woman named Amanda living in a wealthy suburb of Atlanta in the current year 2026. If Amanda is trapped in an abusive marriage today, she might attempt to secure her financial independence by quietly withdrawing funds from a joint bank account, hiring a forensic accountant to trace hidden cryptocurrency assets, or petitioning a family court judge for an emergency order of spousal support. But Amanda in 2026 operates in a system where she has her own individual credit score, her own legal identity, and a capped limit on joint liabilities. Now project that scenario back to the commercial landscape of Providence, Rhode Island, in the year 1740. A colonial wife possessed none of those modern individual rights, but she possessed something far more dangerous to a wealthy patriarch. She possessed the unlimited, legally enforced power to spend his money without his consent, provided she could convince the local merchants that her purchases were absolutely necessary for her survival. To execute this strategy, these women did not act in isolation. The historical trends preserved in the sprawling archival ledgers of colonial shopkeepers reveal a fascinating, subversive economic alliance between abused wives and the local merchant class. Many of these local tavern keepers, tailors, and dry goods merchants held their own deep-seated grievances against these wealthy, abusive husbands, who were often ruthless creditors or arrogant landowners themselves. Seeing an opportunity to exact a pound of flesh legally, these merchants entered into a tacit, highly profitable conspiracy with the fleeing wives. When a woman who had been driven from her home by extreme cruelty walked into a local mercantile, the shopkeeper did not simply sell her a sack of cheap flour and a rough wool blanket. Instead, they began running up staggering astronomical debts on the abusive husband's ledger account, carefully categorizing massive luxury purchases under the legally protected umbrella of strict necessaries. The step-by-step execution of this retail hemorrhaging was nothing short of brilliant. In the colonial legal framework, the definition of a necessary item was not a fixed biological standard. It was entirely relative to the husband's social rank and public standing. If the abusive husband was a prominent merchant, a shipbuilder, or a wealthy magistrate, the wife and her allied shopkeepers would aggressively exploit his high social status. Archival court documents demonstrate that these women began purchasing yards of imported silk bombazine, highly expensive refined sugar, imported Madeira wine, and finely crafted silver goods. When the infuriated husband eventually dragged the merchant to civil court for payment, the wife's attorney would brilliantly argue that, given the husband's immense wealth and exalted station in the community, it would be a severe social degradation and a further act of cruelty to force his wife to dress in homespun wool and eat peasant rations. The colonial magistrates, deeply obsessed with maintaining strict social hierarchies and the visible markers of class, were completely trapped by their own legal logic. Bound by the prior rulings of the agency of necessity, they consistently ruled in favor of the merchants, forcing the abusive husbands to liquidate their own assets to pay for their wives' highly calculated spending sprees. The potential outcomes for the abusive patriarchs were financially apocalyptic. They found themselves completely paralyzed within the very legal system they had historically used to dominate their households. If the husband attempted to physically drag his wife back to the marital domicile to stop the spending, he provided her with immediate, highly public grounds for an absolute divorce based on extreme physical cruelty. If he published another round of frantic newspaper advertisements denouncing her credit, the merchants simply laughed, knowing the courts had already established that his public warnings were entirely legally void as long as she claimed abuse. The husband was bleeding capital at a catastrophic rate. His commercial reputation was being systematically dismantled, and his local political enemies in the merchant class were growing wealthy off of his enforced liabilities. The ironclad cage of coverture, which had historically kept women in total subjugation, had been masterfully transformed into a financial Iron Maiden closing in on the men. This exact economic terror was the specific catalyst that finally broke the patriarchal chokehold on the colonial divorce courts. The historical trends show a massive, sudden shift in male legal strategy. Men did not suddenly experience a moral awakening regarding the rights of women. They experienced pure, unadulterated financial panic. The only possible way for a husband to stop this retail bleeding, the only way to sever his wife's ability to act as his ruinous financial agent, was to completely and permanently dissolve the civil contract of marriage. Suddenly, it was the wealthy, abusive husbands who were rushing into the courthouses, completely dropping their counter-accusations, and essentially begging the magistrates to grant their wives the absolute divorces they had initially requested. They willingly surrendered the dowries, they abandoned the fight for child custody, and they signed the decrees of marital dissolution, simply to sever the financial cord that was dragging their estates into total bankruptcy. By weaponizing retail debt, early American women achieved a profound, unprecedented victory. They had successfully forced their abusers to actively advocate for their liberation. They walked out of the courtrooms as legally independent entities, clutching their recovered wealth, completely free from the men who had terrorized them. But this massive, chaotic transfer of wealth and power deeply terrified the newly forming state governments. The colonial elite and the early American jurists looked at this localized economic rebellion and realized that if women could coordinate with merchants to bankrupt powerful men at will, the entire capitalist structure and the patriarchal hierarchy of the emerging republic were at severe risk. They realized the legal doctrine of the agency of necessity was far too volatile and far too empowering for the female population. To permanently neutralize this threat, the newly established state supreme courts had to completely tear down the legal architecture of the colonial era and invent an entirely new, deeply controversial system of marital financial regulation, a system designed to strictly limit female economic power while still permitting divorce, and the specific, highly restrictive legislative framework they engineered to replace it is the exact foundation that governs the bitter alimony disputes in our modern family courts today. The newly established state governments following the American Revolution looked at the absolute commercial devastation caused by the agency of necessity and immediately recognized an existential threat to the newly forming republic. If local merchants and estranged wives could successfully collaborate to systematically bankrupt the male property-owning class, the foundational capitalist structure of the young nation would be fatally undermined. The early state legislatures and Supreme Court justices realized that the highly localized, relatively fluid common law system of the colonial era, which had inadvertently allowed women to weaponize retail debt, had to be completely dismantled. In its place, they engineered a highly rigid, centralized, and deeply restrictive statutory framework. This new legal architecture was not designed to make divorce easier or more equitable. It was explicitly designed to violently reassert patriarchal control over capital, while technically keeping the legal door to marital dissolution open. This is the exact moment in historical trends where the concept of alimony morphed from a practical, community-driven mechanism to keep women from starving into a highly punitive, strictly regulated financial weapon wielded by the state. To understand the sheer cruelty of this new statutory framework, imagine if we observe a man named Robert navigating a family court proceeding in Miami in the current year 2026. If Robert and his spouse decide to dissolve their marriage, the modern court will primarily utilize mathematical formulas, standardized asset evaluation, and financial calculators to determine equitable distribution and spousal support, largely regardless of who yelled at whom during the marriage, outside of extreme criminal behavior. The modern system, in most jurisdictions, leans heavily toward no-fault principles to ensure neither party is left completely destitute. Now transport that legal expectation back to the newly formalized state courts of Massachusetts or Connecticut in the early 1800s. The new state legislatures completely stripped the local magistrates and juries of matrons of their localized discretionary power. They passed draconian statutes declaring that alimony was no longer an automatic financial right, triggered by a husband's breach of the civil contract. Instead, the state transformed alimony into a conditional reward based on absolute, uncompromising moral purity. The state legislatures instituted the rigid legal doctrine of the innocent and injured spouse. Under this new framework, proving that your husband was a tyrannical abuser or a chronic adulterer was no longer sufficient to secure financial restitution. To extract even a single penny of alimony from his estate, the petitioning wife now had to simultaneously prove that her own conduct throughout the entirety of the marriage was absolutely flawless. The courts demanded an impossible, superhuman standard of female submissiveness. If the husband could prove that his wife had ever spoken back to him disrespectfully, if he could produce a witness who saw her lose her temper, or most devastatingly, if he could prove that she had ever physically fought back in self-defense during one of his violent assaults, the court would legally classify her as partially at fault for the breakdown of the marriage. This classification of mutual fault was a financial death sentence. The potential outcomes of this newly engineered fault system were mathematically devastating for early American women. Let us examine the highly documented case studies from the Superior Court records of the early 19th century. We see countless petitions where women successfully provided overwhelming, undeniable evidence of their husband's horrific physical cruelty, massive financial squandering, and blatant infidelity. The judges, looking at the overwhelming evidence, would grant the legal decree of divorce, dissolving the marriage contract and granting physical separation. But when the proceedings moved to the division of assets, the husband's attorneys would ruthlessly exploit the new statutory requirements. They would parade carefully coached witnesses to testify that the wife was a scold, that she possessed a fiery temper, or that she had neglected her spinning and weaving duties on a particular Tuesday 3 years prior. Because the new laws demanded absolute behavioral perfection from the female petitioner, the judges would seize upon these minor, often fabricated infractions to establish contributory misconduct. Based on this, they would completely deny her any ongoing alimony and often refuse the return of her original premarital dowry. The state essentially dictated to these women that they were permitted to have their physical freedom, but because they were not perfectly obedient victims, they forfeited all legal rights to the marital capital. This was a brilliant, incredibly dark legislative maneuver by the ruling class. They technically maintained the progressive New England tradition of allowing divorce, which prevented the total social uprising seen in other countries with absolute prohibitions, but they rigged the financial mechanics so heavily against women that the vast majority who sought a divorce were guaranteed a life of absolute, crushing poverty. They permanently severed the lucrative alliance between the fleeing wives and the merchant class by making it legally impossible for a woman to claim the agency of necessity if she had even a single behavioral blemish on her marital record. The merchants, no longer guaranteed repayment by the state supreme courts, immediately stopped extending retail credit to abused wives, slamming the iron door of the financial cage shut once again. This brutal statutory environment created a massive, highly calculated chilling effect across the entire New England region. Women quickly realized that stepping into a state courtroom to file for marital dissolution was essentially walking into a financial slaughterhouse. Even if they miraculously won their physical liberty against a heavily funded husband, they would be systematically stripped of their children, their ancestral property, and their basic ability to survive in a rapidly industrializing economy. The patriarchal legal establishment believed they had finally won the long, bitter legal war. By controlling the statutory definitions of fault and innocence, they firmly believed they had successfully crushed the Divorce Now movement and forced women back into silent, permanent submission through the sheer terror of economic annihilation. The magistrates and lawmakers assumed the state archives would simply fill up with the quiet, tragic records of defeated women, accepting their subjugated fate. But they vastly underestimated the sheer strategic brilliance and the relentless, highly evolved adaptability of the women they were actively trying to oppress. When the formal legal system and the statutory courts were completely weaponized against them, these women did not simply surrender to starvation or passively return to their abusers. They meticulously analyzed the new legal landscape and realized that if the state heavily controlled the legal capital, and the state completely controlled the family courts, they had to entirely abandon the traditional, public legal avenues. They had to invent an entirely new, deeply subversive method of survival that operated completely outside the jurisdiction of the male magistrates. If they could not legally force their husbands to pay alimony through the court system, they had to figure out how to completely bypass the patriarchal economy altogether. To achieve this, they began building an underground, highly covert economic infrastructure right under the noses of the Supreme Court justices. The specific, highly coordinated methods they used to establish these shadow economies, and how this invisible network of female capital ultimately set the stage for the massive, explosive legal revolutions of the 20th century, is a story that defies everything we are taught about early American history, and the final piece of this archival puzzle is going to change everything you thought you knew. The realization that the state Supreme Courts had permanently closed the door to equitable alimony forced early American women into a radical economic pivot. They understood that engaging with the patriarchal family courts meant absolute financial ruin, so they completely bypassed the formal legal architecture. They began constructing a highly covert, parallel financial system that operated entirely off the official ledgers of the young republic. This underground infrastructure, meticulously documented in fragmented diaries and hidden community account books, reveals a staggering level of financial sophistication. To survive outside the bounds of traditional marriage and the newly restricted credit systems, women engineered their own localized banks, their own credit lines, and their own completely unregulated markets. Imagine if we observe a woman named Rachel navigating a high net worth separation in Manhattan in the current year 2026. If Rachel suspects her spouse is hiding marital assets, her legal team will deploy forensic accountants, subpoena offshore banking records, and analyze cryptocurrency ledgers to uncover the stealth wealth. Now, transport that concept of hidden capital back to a Massachusetts farming community in the year 1815. Women did not have digital privacy, but they completely controlled the domestic sphere of production. The historical trends show the massive rise of what historians refer to as the butter economy. Women systematically began skimming from the agricultural output of their husbands' farms. They overproduced butter, cheese, textiles, and poultry, and secretly sold the surplus to traveling merchants or sympathetic neighbors. The profits from these clandestine sales were never recorded in the husband's official farm ledgers. They were physically buried under floorboards, hidden in the sewn linings of dresses, or entrusted to female safe houses. This was not merely about individual survival. It was a highly organized system of collective financial defense. The case studies found in the personal correspondence of the era reveal that these localized pools of hidden capital were actively used to fund the escapes of battered women. When a wife needed to flee a tyrannical husband, she could no longer rely on the agency of necessity to force her husband to pay for her tavern room. Instead, she turned to this underground female banking network. Women pooled their illicit butter money to provide fleeing wives with the hard currency required to buy stagecoach tickets out of state, secure safe lodging, and purchase absolute necessities without ever interacting with the formal, male-dominated credit system. They essentially crowdsourced their own domestic liberation, completely starving the patriarchal courts of their jurisdiction because the fleeing women simply disappeared from the local economy. But the shadow economy was not limited to the working class trading eggs and wool. Elite women and their sympathetic fathers engineered an even more devastating legal weapon to bypass the draconian alimony laws. They resurrected and aggressively expanded the complex jurisdiction of the courts of equity. Unlike the rigid common law courts that enforced coverture and absorbed a wife's legal identity, the equity courts allowed for the creation of separate legal estates. Before a woman even walked down the aisle, her father would hire specialized attorneys to draft incredibly dense, ironclad trust documents. These legal instruments explicitly transferred her dowry, land, and inheritance not to her future husband, but into a strict trust managed by a male relative or a board of trustees. The potential outcomes of these early marital trusts were monumental for the trajectory of family law. The legal language was designed with surgical precision to state that the principle and the interest of the trust were for the sole and separate use of the wife, completely immune to the debts, control, or interference of the husband. If the marriage devolved into extreme cruelty and the woman was forced to flee, she did not need to beg a hostile state legislature for an alimony stipend based on her flawless moral innocence. She already possessed complete, untouchable financial autonomy. The husband could not access the capital, his creditors could not seize it, and the state courts could not redistribute it. These elite women successfully privatized their own financial protection, effectively creating the first widespread, legally enforceable prenuptial agreements in American history. The combination of the working-class shadow economy and the elite separatist states created an immense, invisible reservoir of female capital throughout the 19th century. This hidden wealth is the precise, unacknowledged engine that powered the massive legislative revolutions that followed. The standard historical narrative insists that the eventual reform of family law was a benevolent gift handed down by progressive male lawmakers in the late 1800s and early 1900s. The archival records prove this is a complete fiction. Women used the exact capital they had systematically hidden from their husbands to fund the highly organized lobbying efforts, the massive petition drives, and the relentless legal campaigns of the Married Women's Property Acts. They literally bought their own legal identities back from the state using the very money the state had tried to prevent them from possessing. Throughout this masterclass, we have deconstructed the absolute legal warfare buried in the archival records of New England. We have tracked the evolution of marriage from an unbreakable religious sacrament to a highly volatile civil contract. We have analyzed how desperate citizens weaponized abandonment, orchestrated public surveillance to prove extreme cruelty, and manipulated the entire colonial retail market to force their own liberation. We have seen how the state counterattacked with draconian fault laws and highly invasive bodily inspections, only to be outmaneuvered by the creation of brilliant shadow economies and ironclad trust funds. The history of the American family is not a story of passive domesticity. It is a staggering centuries-long legal bloodbath over bodily autonomy, capital distribution, and civil rights. The precedents established in these freezing colonial meetinghouses and hidden ledger books are the exact, direct ancestors of every single custody battle, alimony dispute, and equitable distribution formula operating in our modern judicial system today. But understanding how these early Americans conquered the family courts of New England is only the first chapter of this legal saga. As the nation expanded westward and the Industrial Revolution birthed unprecedented, unimaginable fortunes, the strategies of marital dissolution had to evolve into something far more aggressive and vastly more corrupt. What exactly happened when this underground network of female capital collided with the ruthless railroad barons and the political machine bosses of the Gilded Age? And how did a small, highly secretive group of renegade attorneys completely hijack the territorial laws of the American West to create the very first millionaire divorce colonies, completely immune to the jurisdiction of the United States federal government? The mechanics of this massive jurisdictional heist will completely rewrite your understanding of elite wealth protection, and the shocking details of those territorial archives are exactly what we are going to uncover next.